Welcome to The Explainer. Look, today we're tackling something absolutely crucial, separating cold, hard legal reality from dangerous internet mythology. We're going to strip away all the online confusion and show you how real estate, foreclosure, and property law actually function in the real world.
All right, let's set some ground rules right out of the gate. As this quote hits right on the head, we aren't here hunting for magic loopholes to escape the system. We're here to build genuine legal literacy. You see, people usually only look into property law after they've already been hurt or financially trapped, and we want to fix that right now.
You know, when people are facing the crushing pressure of property disputes, maybe it's a looming foreclosure or a really messy inheritance, they become incredibly vulnerable to bad information. They get swept up by internet gurus promising that a secret treasury account or some magic phrase like, "I do not consent," will just make their mortgage vanish. Spoiler alert, it absolutely won't.
Now, I get it. These claims sound super empowering in a YouTube comment section, right? But step into a real courtroom and wow, that is simply mythology wearing legal clothing. It has zero foundation in reality, and relying on it can expose you to severe consequences, including eviction or massive civil liability. It is not going to save your home.
So here's our roadmap for The Explainer. We'll quickly cover 1. The fake law trap. 2. What is real law? 3. The architecture of property. 4. Foreclosures and estates. 5. The power of procedure. And finally, 6. Real remedy requires reality. Let's dive in.
Section 1. The fake law trap.
So here's the thing. Property law runs on strict records and completely unforgiving deadlines. Filing bad paperwork, that doesn't just waste time, it literally destroys your chance at a real remedy. A bad social media argument just embarrasses you, but a fake legal document can cloud your title, trigger massive tax problems, and actually waive the valid legal defenses you originally had.
Moving right along to Section 2, what is real law? And you can see a really stark contrast here. Fake law thrives on unverified social media posts and, frankly, blind trust in some online guru. But real law? It demands statutes. It demands records, promissory notes, deeds of trust. Real law always asks for the official record, while fake law just asks you to trust an unverified screenshot.
It goes further, too. Fake law wants you to believe that mailing one obscure piece of paper acts like a magic wand to just erase debt. Poof! Gone. But real law demands actual effort. It asks, what does the hard evidence prove, and what is the exact procedural posture of your case right at this very moment?
All right, Section 3, the architecture of property.
Listen, property is not just dirt and wood. In the eyes of the law, it's a highly complex structure dictated heavily by individual state laws. You're actually holding a bundle of rights and obligations. So one person might physically possess the property while someone else holds the legal title, equitable title, or even a tax lien against it.
Now, title is a legal conclusion, yet so many people lose disputes because they argue their emotional belief instead of their actual legal title. Think about it. A deed is only powerful if it's legally valid under state law. You can't just record a random piece of paper at the county clerk and magically manifest ownership.
Which brings us to Section 4, Foreclosures and Estates. When someone is facing the loss of a home, it's so easy to just yell that the bank is stealing it. But a real lawyer, they instantly shift gears and ask, was the foreclosing party actually authorized to act? Because look, a homeowner can make a mistake, but lenders and servicers make mistakes all the time too. Questioning their strict authorization is a grounded, highly factual defense.
Because you don't fight a foreclosure with catchy slogans or notices of non-consent. No way! You fight it with paperwork. As you can see, you demand the promissory note to identify the exact parties, you verify the assignment history to check their authority, you audit the notice of default for statutory compliance, and you track the court docket like a hawk.
And look, this exact same discipline applies to estate management too. Simply claiming, oh, this is family land, means absolutely nothing without the record-based proofs to back it up. If you inherit a house, you immediately need to know who holds the title on the public record and whether a personal representative was legally appointed to handle the affairs. Let's pivot to Section 5, the power of procedure.
This is huge. You absolutely cannot fight intelligently if you don't know what stage of the process you're currently in. Every single step here has completely different remedies and deadlines attached to it. Pre-foreclosure is vastly different from an active scheduled sale. What works brilliantly at Stage 1 is going to be completely useless by Stage 5. You know, people so often mistake their loud confidence for actual legal competence. But real law? It doesn't reward confidence without compliance. The court honestly doesn't care how passionately you believe in your case if you missed the filing deadline or if you showed up in the wrong form without attaching any actual evidence.
And that leads us to our final part, Section 6, Real Remedy Requires Reality.
In property matters, time is, without a doubt, your most valuable asset. Wasting it on fake law arguments while real, hard deadlines pass, that is exactly how you lose your equity. If a redemption period is ticking down, the clock doesn't just magically pause because you mailed a meaningless, homemade affidavit to your loan servicer.
Because true remedies come from real Supreme Court precedents. Take a look at these. Mullane v. Central Hanover Bank is a massive tool for demanding proper due process and notice. Tyler v. Hennepin County protects your surplus equity from being unfairly seized by the government. These are powerful, real-world constitutional tools, but they absolutely must be argued accurately, not just emotionally.
So I want to leave you with this provocative thought for your next dispute. Ask yourself, what would fundamentally change if you began every property issue by asking, what does the record actually show? When you finally drop the mythology and embrace the hard evidence, that's when you step into real legal power. Thanks so much for joining me on this explainer, and I really hope this helps you approach your property rights with true discipline.